but you wouldn't be violating a due process right. If you come in before there has been an actual assignment of the right, you can dismiss for any reason because there hasn't been a property interest created.
Well, we
You
understand.
have 60 days to decide whether to intervene with whatever extensions are granted. But until that moment that the property right is created, you don't have to give a reason because there's no property right. But assume that I believe that once the property right is created, and our cases have recognized that, there has to be something more than constitutional protection, doesn't it?
I don't think so, Your Honor.
A prosecutor can come in and take away somebody's property rights for an arbitrary and capricious reason?
Well, we think
For no reason whatsoever?
We think the constitutional protection means that the government couldn't dismiss a case if doing so was arbitrary in the constitutional sense.
Well, that's my problem, which is, when is it ever proper to take away a property right in the constitutional sense, whether it's for a legislature or the executive, for an arbitrary and capricious reason?
Well,
I have to give some meaning to having a hearing.
I think that's our point is if the relator could show that our exercise of the dismissal right was arbitrary in the constitutional sense.
That's the interest, that's the question that I'm asking. The only thing that in the constitutional sense would be an equal protection violation, a dismissal based on sex, et cetera. But that's not related to the property right in any way.
Well, I think it is, because there wouldn't even be that protection without some property interest that triggers the application of the Due Process Clause. Now, Congress could have layered on top of the constitutional baseline an even more rigorous standard of review.
Well, they did. Good cause. Good cause to intervene suggests that there has to be a reason.
Well, our primary argument is that the government need not intervene as a prerequisite.